Mrs. Lather visited a private hospital for a routine surgery. Due to the negligence of the attending doctor, she developed severe complications. When she approached the hospital management, they denied responsibility, stating that medical services are not covered under the Consumer Protection Act and that she had no right to file a complaint. Now Mrs. Lather wants to seek compensation for the harm caused to her. Can Mrs. Lather file a complaint under the Consumer Protection Act? Yes, she can. Under the Act, a consumer is any person who buys goods or avails services for a consideration, whether paid or promised. A service includes service of any description made available to potential users, including banking, financing, insurance, transport, processing, supply of electrical or other energy, housing construction, entertainment, and other services. If there is any deficiency in service, meaning a fault, imperfection, shortcoming, or inadequacy in the quality, nature, or manner of performance, a consumer has the right to file a complaint and seek compensation. In this case, Mrs. Lather paid for medical services. The negligence on the part of the doctor, resulting in severe complications, clearly amounts to deficiency in service. Therefore, she can approach the Consumer Forum for redressal and compensation. Are medical services included under the definition of service? Yes, medical services are included under the definition of service. In the landmark case Indian Medical Association versus VP Shantha, decided in the year 1995, the Supreme Court of India considered whether medical practitioners and hospitals providing medical services for a fee fall within the definition of service under the Consumer Protection Act. The Indian Medical Association argued that medical services should not be considered services because they involve a personal relationship of trust and skill and are governed by ethics rather than commercial principles. However, the respondents, who were patients, argued that since fees are charged, they are entitled to remedies under consumer law in case of deficiency. The Supreme Court held that medical services fall within the ambit of service under the Consumer Protection Act when rendered for consideration, that is, payment. This means that patients who pay hospital or doctor's fees are consumers, and hospitals and doctors become service providers. Any deficiency in service, such as negligence, wrong diagnosis, or improper treatment, gives rise to a consumer dispute. If a doctor or hospital fails to exercise reasonable care and skill in providing medical services, it amounts to deficiency in service. Patients can file a complaint before the district, state, or national consumer commission, depending on the compensation amount. They can seek compensation for injury, additional medical expenses, mental agony, and other damages. In Mrs. Lather's case, she paid for a surgery at a private hospital. Due to the doctor's negligence, she developed severe complications. As per the VP Shantha case, she is a consumer, and the hospital and doctor are service providers. The hospital's argument that medical services are not covered is incorrect and invalid. Mrs. Lather can file a complaint before the appropriate consumer forum and claim compensation for the harm and suffering she has endured.